webinar. I hope you will enjoy it. My name is Acácio NEGRÃO. I'm a Portuguese lawyer, partner at P.L.E.N in Lisbon, and currently the president of the UIA Labor Law Commission. Well, according to the list of participants that was made available to me, we have at this moment almost 130 attendees, which is an excellent number, and I think demonstrates the current interest of the theme. In this webinar, we will try to answer several questions related to the theme, and we divided those questions in 5 main topics. And to speak about those topics, we will count on the contribution of 6 speakers, 6 brilliant speakers. The first topic will address what are the specific legal duties of an employer in the scope of safety and health at work in this scenario of a pandemic outbreak. And to speak about this topic, we will have Juliette Duval, French lawyer, Deputy Director of the Rule of Law of the UIA, and lawyer at Duval Legal in Paris. The second topic will deal with some specific legal rights of an employer towards its employees, also in the case of a pandemic outbreak as the one we are now facing. And to speak about this topic, we will have 2 lawyers, Meyenburg and Sonia CORTÉS. Michel is a lawyer, an Austrian lawyer, partner of Meyenburg Law Office in Vienna, and currently the UIA representative at the international organizations. Sonia CORTÉS, she is a Spanish lawyer, partner at Abdón, Pedrajas and Molero, and she works in Barcelona, in Spain. Then we will have a third topic in which we will address the situations where the employer is prevented to operate normally because of the coronavirus, of course, and we will try to find out what are the measures that a company can take to face those obstacles. And to speak about these issues, we will also have two lawyers, Federico Torzo and Kathleen Aycock. Federico is an Italian lawyer, partner at Ughi Unzianti in Milan, and Kathleen, an English lawyer, partner at Ferrer in London. And finally, we will have Ulrich Baumann, a German lawyer, a partner at Corp Legal Munich, who will speak about remote work. Finally, in view of the characteristics of this webinar, but also because of the number of participants, I believe that it is preferable that during each presentation there are no interruptions. So I would suggest that the presentations, the 6 presentations that will be made on a continuous manner and without any interruptions. Anyway, at the end, there will be a Q&A session where we will try to reply to the questions that you are able to raise during the webinar. But well, now it's time to start. I hope you enjoy the seminar. Juliette, please go ahead.
So thank you, Acácio. Hi, everyone. Good morning, good afternoon, depending on where you are. So I will start today to talk to you about the duties of an employer in the case of a pandemic outbreak in the scope of safety and health at work. So we will start with the principles that employers and employees have obligation in this matter. And then we will talk about the practical measures imposed upon employers amid the COVID-19 crisis. As you all know, COVID-19 is a major international crisis that has impact on health and on the economy. Why on the economy? Because governments in most European countries have decided to shut down businesses deemed non-essential, such as bar, restaurants, hair salons, museums. But it is very interesting to see that the definition of what is essential or not essential is totally different from one country to another. For example, in France, remain open, obviously, bakeries, but not only, so also remain open wine and liquor stores. So today, we will only talk about the situation of companies which are still open today. We'll start with the principles. The duties of the employers. The employer has an obligation to protect the health and security of his employees. Thousands of pages of the French labor code are filled with preventive measures the employer must implement. For the COVID-19 crisis, the government has added a new set of measures that I will present later on. But what happens if the employer does not comply with the law or the regulation in place? In the worst case scenario, the employee gets sick because of the negligence of his employer, and he may sue his employer in court for workplace accident and ask for damages. But even before being sick, he can also act. He may decide to terminate his employment contract and ask for compensation. He may also use his right to withdraw from the work situation that presents a risk to his health. And also, an employee, a union, or even the labor inspector can launch a summary proceeding to compel the employer to abide by health and safety rules. And currently in France, there are some cases pending, but the most famous of all is the Amazon France case. Amazon France has been closed from April 16 until today. Why is that? Because a union launched an action against the company because the staff were going to work feeling terrified that they may catch the virus. The judge found that Amazon was continuing to operate as if nothing was amiss during the COVID-19 crisis and had failed to put in place reassurances and safety measures for its warehouse staff. And the judge ordered Amazon France to deliver only essential items, such as food, health, or medical products, which only represent 10% of its usual deliveries. And if the company did not respect the ruling, it would have faced a fine of 1 million euros per offense per day. And as a result, the company just decided to close all its 6 warehouses in France in order to evaluate the situation and to see if further security measures could be put in place. But we also said the employee also has obligations. The employee, according to the French law, is responsible for his personal safety as well as for the safety of his co-workers. And if he doesn't abide by his obligation, he can be dismissed for gross misconduct. So now, let's focus on the practical and specific measures imposed upon employers amid the COVID-19 crisis. First, the employer has to keep employees as much as possible away from their workplace, and then he has to ensure safety in the workplace. Keep the employees away. It means in practice, all employees who do not need to be on site must work remotely from home. Employees at risk, such as pregnant women, seniors, people with health issues, they must either work from home or be placed on paid leave. And employees who need to take care of young children under the age of 16 or fragile people may be placed also on paid leave. Ensure safety in the workplace. What does it mean in practice? It means first that the employer has to inform and train his workforce. So he must assess the existing risks in his company, which means the circumstances in which his employees may be exposed to the virus. For instance, too many people working in the same room, in the same confined space, which was the case for Amazon. The impossibility to have 1 meter distance between the employees and the customers, which is often the case in supermarkets, or even the presence of the virus on the surfaces, on the floors, on the equipment. After assessing the risks, the employer shall implement the necessary measures to avoid or, failing that, to limit these risks as far as possible. And the employer has then to inform and to raise awareness of each of his employees about the risks and about the measures to be applied. For instance, the barrier gestures. You sneeze in your elbow, you cough in your elbow, you wash your hands. And he also has to train his employees on how to use the protection supplies he will give them and how to react in case of an infection. This is very important, for example, for people working in domestic health sectors, because they are in direct contact with people potentially ill and potentially contagious. And the whole of this must be carried out in collaboration with the labor doctor and with the employee representative, who will help to identify day-to-day risks and also to help give the information to all the employees. The employer also has to reorganize the workplace. So how does he do this? He has to respect the general requirements of the government. So these general measures that we all know, you have to have a social distancing measures, so 1 meter between people. You have to have barrier gestures that I mentioned earlier. You have to provide masks, gloves, hand sanitizer to everyone in the company. Meetings in person must be limited to only the mandatory ones, and all non-essential trips must be canceled. But that is not enough. If the employer stops at those general measures, he will be sued, he will be fined. The employer must implement specific measures to protect his employees against the possible risks existing in his company. So this is why the government, to help companies, has published good practice examples for certain sectors. For the delivery sector, for example, there is no signature requirement anymore to assess the delivery, and there is not even any hand contact anymore, because you have to deliver with drop-off on the ground in the presence of the customer. And for me, the postman went even further, because he didn't even come to me last time he delivered something. He called me through the intercom and said, I put your packet in the elevator and you just have to collect it when it arrives at your floor. In the retail sector, there are some other measures to accept a limited number of customers in the store at a time. You have an entrance door and an exit door, and those are completely different so that people don't touch another or don't cross one another. You have marks on the floor to show the customers how far they must stay from each other. And also, people have installed plexiglass screens at the checkout stations to protect the cashiers when the distance measures cannot be kept with the customers. The employer has then finally to constantly reassess the risks, adapt the measures, and make sure that the rules are followed by everyone. Thank you very much, and please stay safe.
Hello. Hello, also from my side, good afternoon, good morning. I just wanted to tell you a little bit about possible legal rights of an employer towards its employees in our legislation. What I wanted to give you, first of all, maybe some ideas what we should do as lawyers. Therefore, the first important thing is just check the law. It's not so easy as already Juliette told us, and it's very, very complicated these days. And hopefully we will be able to check all of the respective different kind of labor provisions that are in force. We should also see about our general rules we have. I've put, for example, one general rule on the slide. That's the most important one in Austria, similar to specific other probably you will have in your countries. We have to also try to get the other rules to be done. I just mentioned a little bit like data protection, collective labor law, care through health and safety, administrative law on epidemics, penal law provisions, and also civil law. Juliette has told us that in case something happens at the workplace, we have to be aware of the fact that it can be a disease on the premises, but be aware of the fact that it is not seen to be occupational disease. COVID-19 is something else. There are some limitations we have in Austria with regard to occupational diseases will not work. So the damage is an employer is not acting correctly can be also in civil law damages in a huge amount of money, and some class actions are already underway. I'm just sorry for this short interruption because I'm jumping from one slide to the other. Now we have the right slide. What we should think about is also what we can do during the crisis. And I would also like to, before I hand over to Sonia, something to tell you what we should think about after the crisis. During the crisis, we have to see that all the different epidemic law provisions are changing all the time, and we cannot give a direct and found legal opinion in a hurry. So we have to just tell our clients this is the case, and we have to find about immediate action. In our assessment, I think the most important thing is possible right employers that we have to be careful.
Oh, sorry to interrupt you, Michael. We don't hear you. Yeah, we don't hear you well. Sorry, it seems like there was.
Better now?
Yes, now it's better.
But in the trial, it was working. But there's some noise also in here, but there's no noise with me, so I don't know. Okay. Most stringent interpretation is important, and one has to see it versus the possible dangerous consequences of non-fulfillment of authority. So we have to be very, very careful. And if possible, tell your clients that even a short documentation will maybe good to have for further discussions that might come out later on. So just some hint, scribbled notes is better than nothing. We know right now that courts and authorities are not working, but they will be overworked and no decisions are made right now, but we will have some decisions in the future, and we will have no idea how the outcome is. Therefore, also we have to be very, very careful in advising, and we have to see that we work both and in a not discriminatory way. So this is what I wanted to see if I can switch on. Yes, now it's working, sorry. I just wanted to put a note of what we should do after the crisis. After the crisis, we will have to go into individual employment as well as in collective agreements and secondment agreements to see if these are still up to date or not. Just to give you one case, in Austria, we had a cleaning woman who was cleaning an office of nuns and ladies, and they found out that almost all were infected. Why were they infected? Because the cleaning lady was after work time working at the bar in Ischgl, and there she got the virus, and all the poor older ladies were then of course infected, only due to the case that nobody really mattered and did care that the cleaning lady, probably only part-time employed, was contested. So we will really have to have a look into our individual employment agreements, and especially also in secondment agreements, we will have to see what we will have to change. I've put some frequent answers and questions about the rights of an employer. I will most of them hand over to Sonia in a minute, because they are more or less the same way treated all over, and so it's maybe easier if Sonia is going to do it. What I just wanted to add for the Austrian part is we know about travel, that it's not allowed to travel for the time being, that the employee can refuse to go on business trips. Right now we don't have any business trips. Question about employee to avoid to go to work or commute is a good question. As long as he or she has to work and no home office is available, then of course also commuting will have to be allowed. Just 2 or 3 sentences about termination of employment. Very important thing. We have right now a short-term work system working, and about 900,000 employees are on this working scheme right now. 500,000 are unemployed, so it's a big issue, you can imagine. And in case of an agreement with a short-term agreement, then of course termination will not be allowed. Can the employer send an employee to holidays on vacation? Yes, of course, but the general rule is payment of wages and salaries will have to be paid any way. There's no way for a company to invoke force majeure because of the COVID-19 crisis and just simply stop paying wages or salaries. One interesting question I still have is the question, what will happen in the case of secondment? Right now it is clear that the employer had the duty to get the employees from other countries back as long as it was possible. In case this was not be done, of course, then it is clear that the employer will have to pay on the salary of the person that is seconded somewhere in the world and maybe has no work to do, but still could not come back early to your country. This is, for the time being, I think, everything I wanted to say in a rush, and the rest is in the very good hands of Sonia.
Thank you, Michael. Go ahead, Sonia.
Thank you. Good afternoon, everybody. The presentation I will deliver is about what the employer has to do with respect to a situation of pandemic at work or in general. I'll cover a number of points. Basically, what are the general principles, then the information that the employer can collect, and what are the restrictions from the point of view of data protection law, and finally, some practical remarks on how to deliver a consultation process while all employees are teleworking. One of the main points and experiences we are having in this situation is that everything is quite new, is applying old principles, old piece of legislation to a completely new situation, a pandemic. And that raises a number of challenges in applying the law. We've also had new legislation, so things are new, and we're sometimes applying the test system where the law, there's new legislation, it has to be implemented, and then things come up that are not working for specific employees, like trying to get benefits where the website has collapsed. What are the situations at work? But what I'm finding personally in trying to advise clients is that some answers I might have delivered some days ago, 2-3 days ago, are no longer valid, not only because the law has changed, but also because the situation is completely different. And you will see throughout my presentation. As regards data protection, what we are finding is that there is a clear case of a conflict between employees' right to privacy and the other employees' right of safety at work, and also the employer's obligation to ensure a safe workplace. And this test, as I was saying, is evolving. The interpretation is very different as the pandemic has been increasing. You may all know that under European data protection law, the employer cannot obtain certain pieces of information, personal details. It cannot collect, process, and store it unless there are certain requirements, certain principles. And this is where it's so key here how things are changing. Basically, the employer now has a legitimate ground to interfere with employees' privacy in certain situations, because given the pandemic, there is a major need to implement certain measures to protect our employees. So when trying to answer certain questions that we may face in the pandemic situation, the tests of necessity, proportionality, reasonableness have to be answered. And the answer is different as the pandemic evolves. What is, first of all, what is the justification, the protection of health of our employees, other employees at work, and the actual employee himself, his family? What is the principle of proportionality? The principle of proportionality is that the Employers Act has to be justified, is justified as long as it's necessary. And it has to be reasonable, meaning that this, the purpose cannot be obtained through other means which interfere less with employees' privacy. And obviously, when seeking all these information, processing information, all this information has to be kept confidential and, if at all possible, pseudonymized. Why am I saying that this is evolving and that this is changing throughout time? Well, basically, because at the beginning, when there were a few cases maybe in China, maybe a few cases where everybody was saying, well, you know, this is simply the flu, general flu. There's no issue. Why should the employer ask certain questions? Why should the employer take employees' temperature? This was out of the question. But once this has become a critical situation, hospitals are absolutely busy, and there are no means, there are no more beds to take care of people who fall ill, where elder people are simply dying, where colleagues at work start to get ill, then it becomes an emergency. And then the employer has the duty and the obligation to protect employees, to implement all safety measures, and try to keep everybody safe. So it's at that point when things are changing, and we're right there now. What kind of questions are we having? Well, the first question is, can the employer inquire on the employee's symptoms or diagnostic or current, or whether that person, that employee has been sent into quarantine? At the beginning, say no, you know, whether an employee is ill or not. In most jurisdictions in Europe, in this particular case in Spain, it's special protected piece of information, and therefore the employer is not entitled to get that information. That is held by doctors in specific cases. By the way, the employee has been signed off sick. But now that is very important, because the employer needs to know whether some of the employees might be at risk. And that involves perhaps even, is any of your relatives ill? Has any of your relatives been declared infected by the virus? That is key. That is key information. Just a few minutes ago, I had a query from a client saying the husband of one of the employees in our company is infected. What should we do? Can we ask the question? And should we inform other employees? What do we have to do about that? So yes, that information is key to protect other employees. And so the employer has the duty to seek that information. Obviously with all sorts of protections and all sorts of proportionality. It's not the same doing this 2 months ago than it would be asking the question maybe in 6 months. Well, yes, we don't know. What the employer cannot do is send out a questionnaire with all sorts of questions regarding health which are not strictly relevant. The information to be asked, the questions have to be those strictly necessary to protect other employees, and to ensure the employer places all the information. What should the employer do when the pandemic is really there? One of the things would be taking employees' temperature. But should this be done through other means? Does the employer need to do this at work? We at least in Spain, we call the health and safety service provider. It's either an in-house department or it's an external company, might be outsourced. But there are doctors there. So the temperature would be something that those doctors would do. It's a private detail that company itself does not need to know. So it would be doctors who carry out those checks and who disclose this to the company when there is an issue. The name of the employee does not need to be disclosed, but the employer will need to know who is suffering an issue, an infection, maybe the department where that person is. The next query would be, can the employer disclose this information within the company? What should he do with this information? Well, yes, other employees are entitled to know certain pieces of information. How, when, how to disclose this? Well, the way this would be disclosed would be to the Health and Safety Committee, where employee representatives have been appointed, discuss what's the situation and what's the extent of the infection. The employer has the initiative, has to decide what measures to carry out. Maybe there's an obligation to close the plant. But normally, if all the measures have been implemented, all the employees are wearing masks and wearing gloves, and the 2-meter distance is implemented, then there is a decision as to whether to close that particular department, whether to inform the employees who have been working close to that infected employee, whether to recommend that they take a test, and even to implement even stronger measures. Okay, I see a picture, so maybe Colette can see what's okay. Thank you. I'll carry on. Another question is whether employees have visited countries which are well known to be under the pandemic. At the beginning, those were a few countries. Now, many more countries are there, and therefore, this would seem no longer to be reasonable to be asked. Can the employer process the information? Again, yes, but subject to the principle. So, is this necessary at some point? Well, probably it's necessary to protect the employer if there are any claims. You know, why did the name of this employee become public? Maybe the employer did not disclose the name of the employee, but that employee who was infected or who was placed into quarantine because her husband was declared infected, maybe that person was subject to quarantine. And so everybody became aware that that was the person who was subject to the issue. So it's at that point that the employer can perhaps keep that information. But knowing that this is strictly interpreted, the general principle would be this does not seem to be necessary at some point. Can individuals, can the data subject request the erasure of the information that has been processed? Probably at the beginning, no, because the information is very relevant so that the employer can keep trace of where the infection is in the workplace. The specific employees who have been infected at that point who are under quarantine or so. Going forward, as many other employees are becoming infected and they're off sick, probably that is no longer necessary. And therefore, perhaps it comes a point where the information has to be erased. Now, I'd like to consider with you some challenges we've found when trying to carry out a consultation process in the workplace when implementing a furlough, so placing employees into furlough. We're having all employees teleworking. Some might even be ill. We have to implement some measures at work, and we need to first identify who are the employees we need to carry out the the consultation process. In many cases, employees haven't simply elected their representatives. So this has to be done while everybody's at home. We just carried out a consultation process with 1,000 employees, all working from home. So it was challenging, but at the same time, it was interesting. The way this was done was an email was sent to all employees saying, we need to carry out a consultation process. So you have to elect your employee, your representative. This is what the law says. The company obviously cannot interfere in the process, but it can assist and advise. They did appoint their representatives through a voting system. There are many systems. One of these is by Google. And once they were appointed, we started the consultation process. There had to be minutes that had to be signed. How are we going to sign minutes if everybody's out of the office? We used a system. There are several, like DocuSign or Signaturit, several. It worked very well. You received the minutes. You would get your name there. You would be asked to check, and you would sign. And then this was sent over to each one of the 20 people who were sitting in the table in the negotiation board. Went very well. Same with the agreement. And actually, everything worked very well. We had the agreement, it's been implemented, and we're using this with several clients when we've been in consultation. In any case, we are anticipating that probably there may be claims going forward because it's almost impossible to get the exact compliance and all the evidence you might want to get to comply with the law. Thank you very much for your attention and keep safe.
Thank you, Sonia, very much for your presentation. Very interesting. Now, Federico, the floor is yours.
Okay, thank you. I think I'm going to try to be quite short because I think we are running a little bit later. And of course, we need time for possible questions. Allora, let me see if we can move the slides with my PC. Doesn't seem to work. Okay. So I'm going to talk about the measures enacted by the Italian government specifically, but my understanding is from most of the other governments in Europe to deal with the reduction of work Juliette was talking about before, due to the coronavirus emergency. And basically, let me see if the slides are moving. These are the Italian sources, legislative sources for the measures which were enacted. I guess the presentation will then be open for downloading by the participants. So this is just a matter of reference. But basically, there are two measures that the companies were able to enact in order to reduce the cost of the workforce since production was basically closed, locked down by the decision of the government. One is to have the employees use their accrued unused holidays, and the other one was recourse to the various forms of short-time agreements available under the various legislations. I have to say that the slides are not really working very well. I'm going to try to do it from here. Okay. Okay. Allora, in Italy at least, companies were encouraged to have employees use their unused days of holidays, because this, of course, was a balance between the interest of the workers, the entrepreneurs, and the government, in the sense that, of course, the government put money on the table, but possibly, you know, there was not enough money to cover all the, let's say, damages deriving from the closure of the businesses. Of course, entrepreneurs were already doing their part, because being the business closed, of course, they were not able to pursue their economic financial interests. And so in this way, some, let's say, of the burden was also put on the employees, who somehow were using days of holidays, but not, you know, really to go to the beach or to have some traveling, but just to stay at home as requested by the government. So basically, the principle was that before actually using subsidies of the government, you had to ask your employees to use their unused days of holidays. After that, the government put money on the table under the form of these short-time arrangements. This kind of arrangements, which now I understand also from Kathleen, have like a new name in the UK, follow, something like that. Kathleen is going to be able to tell the exact word, but in any case, this happens in Europe when employees are suspended from work and their salary is paid by the government instead of being paid by the employer. So in Italy, the first thing that the government did on March 17 was to basically provide for a special fund in order for employers to be able to apply to this salary integration by just referring to the COVID-related emergency. Usually a company, if they want to apply for this type of salary integration, they have to demonstrate that they are under financial distress, that due to economic reasons they are facing a reduction in production, in sales. In this case, companies had just to indicate in their application basically coronavirus emergency, and by doing that, they were able to access the salary integration fund. And basically, as now the government granted a salary integration fund for 9 weeks to be used between February 23rd. So somehow when the measure was enacted, it had already a retroactive effect. So if employees had already been left at home because of the spreading of the virus, especially in certain regions of Italy, the application for the salary integration was, possible to retrodate it to until February 23, and this 9 weeks must be used within August 31st. These are the amounts in the sense that, of course, the government is not able to cover 100% of the salary. It covers 80% of the salary, but in any case with certain caps, which are approximately 1,000 euros. It depends from the amount of the gross salary. So, of course, also the employees have a damage by being, suspended, in the sense that, of course, they don't work, but they get only reduced salary. If the employer is, in a very good financial situation, of course, the employer can decide to top up let's say the salary integration with its own financial means up to 100%, or even, a different portion of the salary, up to 50%, whatever. Okay, and some specific questions, and then I want to leave the floor to Kathleen. Of course, I mean, this system, at least in Italy, and I guess it might be the same also in other European jurisdictions, is somehow self-administered by the employer, in the sense that once I have made the application to the Social Security Agency to receive this, for the employees to be paid, you know, the salary integration by the employment agency, I usually file the application for, you know, 100% reduction of the working hours and for all the employees. But then I can, of course, decide to have some of the employees come back to work and work possibly a reduced working hours. And then, of course, when I do the pay slips at the end of the month, I indicate, you know, the hours that they have worked, so that, of course, I will pay as the employer, and the hours they were suspended, so they're going to be paid by the government. Of course, there is a big issue, especially in case it's not, you know, 100% reduction of the workforce. If I can, you know, cherry pick which employees are entitled, should go to work and which should not, because of course people that do not go to work get less money, because as we have seen, in any case, subsidy by the government is lower than the regular salary. There should be, you know, a rotation between homogeneous job profiles. The employer should make sure that, you know, employees rotate in coming back to work. In Italy, of course, this 9 weeks, let's say, salary integration applies to the company, not to the employee. So I cannot, you know, decide that first I suspend for 9 weeks a certain number of employees and then another number of employees. The 9 weeks period refers to the company. And then what happens if employees get sick? In case of total suspension of you know, the production of the working activities, employees basically are not entitled to the usual sick pay. They just get the salary integration by the government. Again, if there is only a partial reduction of the activities, then the employee enters into sickness leave and is paid the sick pay, which is somehow closer to the regular salary rather than the salary integration. And basically the same applies also for holidays. If you are 100% on, you know, all the workers are suspended, then basically they cannot ask for holidays because they are suspended and paid by the government. If there is only a partial suspension, then of course employees could decide to go on holiday, and the government and the employer would have to pay for them. So this is just let's say some you know, hints on how in Italy this system is managed. Of course, it may vary from country to country. Kathleen possibly is now going to give us a different perspective from the UK. And so thank you for attending this great seminar. And Kathleen, the floor is for you. Hello, Kathleen.
Thank you, Federico, for your presentation. Kathleen, I would only kindly ask you to be as concise as possible because we have only 30 minutes left, okay? Sorry.
No problem. I'll be concise and I'll try not to speak too quickly, which is a bad habit of mine. Happily, there are quite a lot of similarities between the UK scheme and the Italian scheme. So there's some things in Europe which the UK still join with Europe in the way it deals with things. So so I should be able to be quite quick. I don't seem to be able to move my, there we go, slide on. So I'll just go straight into it given the time, and I'll set out what options are available to employers in the UK when they are looking to manage their workforce, to just try and manage their own costs in this crisis when they're not bringing money in. And of course, salaries are a very large part of any organisation's outgoings. So there's 4 options there, which I've set out on the slide. The bottom 3, short-time working, unpaid layoff and redundancy, aren't new. They're things that we've always been able to do, and so there's nothing corona related for them. But the first one on the slide, the furlough scheme, that is a new that's a new specific scheme which has been brought in for the coronavirus and is very similar to what Federico was just talking about. So I'll go into each of them in a bit more detail. I can get the slide to move on. Sorry, I've gone too far. There we go. So under this scheme, employees who are furloughed, which just means they're asked not to work, and then as in Italy, the government will assist with some of the wages, and it's a very similar amount. Employers can claim 80% of their employees' wages, up to a maximum of a gross amount of £2,500 a month. So for the majority of the population, that's going to be most of their salary, and that's going to be a good payment. Of course, people in certain sectors, that is not going to touch the sides, and that's not going to be very much of their salary. But for most people, that's a good amount of payment that the government is paying for itself on behalf of the employers. Employers can choose to top up the wages if they want to, so that's the same as in Italy and around Europe, but they don't have to. What's really significant is that the employees must not work or provide any services at all during that period. Even if the employer is choosing to top up the salary to 100%, they can't do 1 minute of work for that employer during the furlough period. Of course, they can volunteer, and there's a lot of people volunteering in the community and for the health service. They may even be able to do work for another employer. We're trying to find out if that's allowed. It's not clear at the moment, but they can't do any work at all for that business while the government is paying for their salaries. And the scheme opened for applications just on Monday, so we're getting lots of questions from clients as to how it works. Move on to the next one. So currently the scheme is going to run until the 30th of June, and that's already a later date. So it was going to be till the end of May, but they've extended it. So this scheme will be open until the end of June, and maybe it will go further. You can only apply for this if you were on the books. So if you were an employee on or before the 19th of March, and that's because that was the date that the government announced the scheme would happen. So it's preventing people abusing the scheme by taking on an employee, maybe their wife or their husband or their sister, to try and get government payments. If you weren't employed before the 19th of March, then you can't get it. That's quite difficult for people who are moving jobs, but the government had to put a cap on it. Now, one of the things which has changed in the panelists were just discussing before we started, that all governments are adding to this schemes almost daily, it feels like, and clarifying things. So there's always little tweaks and changes. And one significant one is that at the beginning of the furlough announcement, then the employer could decide whether they put the employee on furlough or whether they didn't. And the employee hadn't, we thought the employee had no choice in the process at all. In fact, just on Friday last week, the government said, actually, no, you have to have consent from the employee before you put somebody on furlough, without saying, you know, what would happen if the employee refused. I suppose the business might go bust. But the difficulty for a lot of our clients is they had already placed staff on furlough weeks ago and hadn't got their consent. And now, of course, they're having to go back and look at the process. But going forward, consent must be asked for. And then anybody on furlough has to be on furlough for a minimum period of 3 weeks. So you can't have 1 week and then back and then out again for a week. It has to be 3 weeks. And it could be, you know, all the way to June. You could say now that you know you're not going to have anybody in until June. But the way that the claims are being processed means that you're probably going to want to make small claims for each period of time. And it can get quite complicated if you're going to have different people on leave at different times. And I'll just make the same warning that Federico made about discrimination, because employers are obviously having to choose which employees do they furlough and which don't they furlough. And there's a danger that people choose in a way that could be discriminatory, maybe women with children or employees who have sickness and therefore aren't performing very well anyway due to their sickness. And of course, the way that you choose people to go on furlough could be the subject of a discrimination claim later. So everybody should just have an eye to that. A big issue, and it sounds like it's the same in Italy and maybe around Europe, is holiday entitlement. And initially, a lot of employers were putting people on furlough and then saying, now you have to take holiday, and only paying holiday at that lower rate of 80% of salary. But what the government has just clarified in the last few days is that you can put people on holiday. So the employer can say, you have to take your holiday. But if they do that, they have to pay the full amount of normal salary. And also during furlough, people are accruing holiday. So if you're on holiday, if you're on furlough for 3 months, then at the end, and you don't take holiday, then at the end of that 3-month furlough, you'll have accrued 3 months worth of paid holiday, which you can then take. Of course, lots of employers are very worried about this finishing, everybody going back to work, getting business back together, everybody working really hard, and then 3/4 of the workforce saying, right, now I'm off on holiday to the beach and I'm not going to come into work. And of course, that would have a huge economic impact. So we're just trying to manage that at the moment. And the government hasn't really provided quite enough guidance as yet.
Kathleen, thank you very much for your presentation, and sorry for the rush, but now we need to move on Uli's presentation, okay?
Yeah,
Uli,
that's the main furlough, that's fine.
Thank you. Uli, I would kindly ask you to only say some main aspects of the main aspects of your presentation, okay? Because we only have 4 minutes. Thank
okay.
You.
Sorry, Uli.
I presume that all our presentations will be online and can be loaded down by all participants. So okay, now I'm in my presentation. First, I want to talk about the definition of mobile working, which could be in various definitions, like home office, alternative teleworking, center-based teleworking, and on-site teleworking. And I'll just give you here a definition of mobile working. What I'm going to do now is I want to talk about the scope of only home office activity and termination options. So first of all, you have to check if your employment contract, shop agreement, legislation, or jurisdiction is going. Sorry if somebody is fiddling around with my presentation. Yeah. Check if your employment contract, shop agreement, legislation, or jurisdiction is giving the option or duty for the employer a specific right or claim of the employee to work from home. So we are talking about optional or mandatory home office work. And please keep in mind that the Works Council's rights of co-determination must be observed. The Works Council must be involved in a timely manner when introducing and changing home office regulation. So there's generally no obligation to work in the home office because the employer does not have the control over the employee's private rooms. If something else is to apply, a regulation is required which specifies, first of all, the amount of time spent in the home office, whether the employee is only entitled to perform part of the work from his home office based on his own decision, or whether he is even obliged to do so. Then a duty to provide a home office workplace and to use it permanently or at least on some fixed days of the week. A possibility of revoking the permission to work in the home office at the employer's reasonable discretion if, for example, substantial reasons after weighing up mutual interests suggest that the employee should again work permanently and exclusively in the company. So you must find a solution to call him or her back into the company, into the office. Let's talk about equipment of the home office. This I can do much quicker. In principle, the employer has to provide the tools that the employee needs to carry out. I've got problems with my mouse. So we need point 3, please.
Sorry to interrupt you, but we only have 1 minute left, so I think we will have to conclude. Anyway, I must say something to all the participants. The first thing is that, well, the PowerPoints will be available in the website of the UIA. And of course, we had planned to dedicate a few minutes to a Q&A session, but sorry, there's no time left for it. But don't forget also that this webinar has been recorded, and therefore you will be able to see it again whenever you want. There are many questions raised by the participants. We will try to reply to them. If there is an email or a contact, we will do it immediately after this. And well, sorry for this. The idea was to have a Q&A session. It is not possible, but well, I wish you have enjoyed it, and well, stay safe, and hopefully this crisis